Imagine waking up one morning to find out that you no longer can get a mortgage on your property.
Own your life.
This happened to 150 landowners in Richmond, British Columbia. Let's talk about that. What if I told you you could own a home, you could have your name on title, have a mortgage, pay property tax for decades, and then one court decision decides uncertainty over your ownership and what that actually means? This is exactly why so many homeowners, lenders, realtors, lawyers, and investors are watching the Cowichan Aboriginal title case in Richmond. And before anyone twists this is not an anti-Indigenous video. This is not about blaming First Nations. This is about one massive legal question. What happens when Aboriginal title and private property title overlap? Because in British Columbia, that question is no longer theoretical. It's happening right now. And if you own real estate in BC, or Canada for that matter, or lend money against real estate, or invest in real estate, you need to understand this. Because this problem is not just the land claim. The problem is uncertainty. And the real estate market, it hates uncertainty. Section 1. What happened? In August of 2025, the BC Supreme Court released a major decision in Cowichan Tribes versus Canada. The court recognized Aboriginal title over a portion of land in Richmond along the Fraser River. This area includes industrial land, government-owned land, port-related land, and some privately held land. This is important because Aboriginal title was recognized on land that overlaps with fee simple ownership. Fee simple is what most people think of as normal private ownership. You buy a property, you get registered on the title, the bank lends against it, the land title office records it. Now everyone moves forward assuming that the title is secure. But this decision said something very different. The court found that Aboriginal title can coexist with fee simple title and that Aboriginal title is prior and senior in right. Legal commentators have described this as the first Canadian case recognizing Aboriginal title land that includes privately owned fee simple property. That is the sentence that should make every real estate person stop and pay attention, because if one form of the title is prior and senior, then lenders, buyers, sellers, title insurers, and homeowners all have to ask, what does ownership actually mean? Section 2. Why homeowners are concerned. The city of Richmond sent notices to about 150 property owners warning that the decision may affect their property title. Now, to be clear, the court did not simply cancel private homeowners' title. And the Cowichan representatives said they are not trying to remove ordinary homeowners from their homes. But here's the real world problem. Banks don't lend on good intentions. Banks lend on title certainty. If a lender thinks there's a cloud on title, or if a title insurer gets nervous about the situation, or if lawyers cannot give clean advice, that can affect the financing. That can affect renewals, refinances, that can affect sales, that can affect property value. There were reports and public concerns about mortgage renewals and lending uncertainty, although Premier David Eby later said the province had spoken with major banks and credit unions and were told policies had not changed. That's not what I'm hearing. Policies may not have changed, but their ability to provide mortgages on these properties at the time of this recording certainly has. So the issue is not necessarily our homeowners being kicked out tomorrow. The issue is what happens when the financial system starts treating this land as risky. If financing becomes difficult, then you've only got cash buyers as the only percentage of the buyer pool. This hurts the value of the home. I would not be surprised if legal action eventually follows, costing taxpayers even more money. To make matters worse, the media initially focused on a fishing rights component of the case, while broader title implications received less public attention early on. Section 3. Why this case is different. A lot of people hear land claim and think, oh, it's just another government negotiation, but this one's different. This went through court. It resulted in a declaration of Aboriginal title, and it dealt directly with the relationship between Aboriginal title and fee simple ownership. The province disagreed strongly with the decision and announced it would appeal and seek a stay. That tells you how serious this is, because if the province thought it was no big deal, they would not be fighting this hard. The court also rejected the idea of BC's Land Title Act automatically protecting fee simple title from Aboriginal title claims. Legal summaries show the court found Aboriginal title exists outside the normal provincial title registration system. That is the part that matters for real estate, because BC's land title system is built on confidence. If buyers, lenders, insurers, and investors start asking, can I really rely on title? That affects everything. Section 4, the bigger area. The land actually claimed was larger than the area recognized by the court. Richmond says the Aboriginal title that was claimed was over 1,846 acres in the city of Richmond. The court recognized area has been reported to be around 732 acres. Immediately after the first successful claim, the same group, they are now seeking a substantially larger portion of land just north of the first claim. And that's making people very nervous, because if this principle applies here, where else could it apply? That is the bigger question. Not just Richmond, not just 150 homes. The bigger concern is precedent. 0 homes are selling anywhere near this zone at the time of this recording. This decision also caused trouble around other areas. For example, due to the major land claim in Kamloops, some mortgage providers refuse to lend in those areas now. This could become a very concerning trend. Section 5, why mortgage people care. From a mortgage perspective, lenders care about 3 things. Can the borrower pay? Is the property marketable? And can the lender enforce security if something goes wrong? The third one is the main issue. If a lender ever had to foreclose, could they sell the property cleanly? Would title insurance cover them? Would another buyer's lawyer approve of this purchase? Would another lender finance the next buyer? That's why this matters. Not because every lender is panicking, but because mortgage lending is based on confidence. And once confidence is questioned, even slightly, deals can slow down, transactions can stop, renewals become more complicated, or they become impossible at all. And buyers, they're going to demand discounts. Section 6, recent Supreme Court decision. The Supreme Court just changed the tune and decided that Aboriginal title can't be declared over private land. According to the Global News, this will directly affect the Cowichan case in Richmond, BC. The refusal by Canada's High Court to hear the First Nations appeal against the decision in the New Brunswick case establishes a precedent that First Nations can seek compensation for loss of traditional lands, but they will not be able to assert ownership. The Crown Indigenous Relations Department says the ruling will inform arguments in other cases, including Cowichan, adding that private property rights are fundamental. The BC Supreme Court's ruling in favor of the Cowichan Nation found it established Aboriginal title to more than 5.7 square kilometers of land along the Fraser River in Richmond. And the provincial and federal governments and other First Nations are appealing that decision. However, according to criminal lawyer Kyla Lee, the media is not sharing what actually happened.
The Supreme Court of Canada did not rule on Indigenous title not applying to private lands. You might have seen some headlines this week that said that the Supreme Court of Canada ruled by declining to hear a certain case that Indigenous title or Aboriginal title can't apply over private lands in Canada, but that is not what the Supreme Court of Canada ruled. What happens with a case for the Supreme Court of Canada is that you have to apply for leave to appeal the case. You have to ask the court permission to hear the case, and the court only hears a very small number of cases every year. And those small number of cases have to be accepted based on a set standard of criteria. The criteria requires that the case raise an issue of national importance. And the court may decline to hear a case even if it raises an issue of national importance, like whether Aboriginal title can coexist with private landowners, on the basis of the fact that there is an improper or incomplete record at the lower court level for the court to fully analyze and address the issue. The fact that there might not be competing judgments between appellate courts across the provinces that need to be reconciled. The fact that it's just not the right time for the court to hear the case. The court can decline it for any reasons, and they don't give any reasons why they decline it. Declining to hear a case is not an endorsement of the judgment. It's the court saying, no comment. We're not getting involved this time. Bring it to us again some other time, and we may decide to hear it based on whatever record is advanced in that particular case. But on this case, in this circumstance, we're not going to hear the appeal. So that means that in the New Brunswick case that's at the heart of this, that judgment does stand. But that judgment only stands in New Brunswick. It's only binding on New Brunswick. Any other appellate court or even superior level court can decide differently across Canada because appeal courts in one province are not binding on courts in another province. They do have persuasive value, and often they can be relied upon for that persuasive value, but they are not ruling on anything in other provinces. So if the BC government in headlines or news articles in headlines say that this issue of Aboriginal title coexisting with private land ownership has been decided by the Supreme Court of Canada, and that the issue is no longer live, and that there isn't Aboriginal title that coexists with private lands because of what the Supreme Court of Canada decided not to hear, that is a misstatement of the law, and don't be misled by it.
Section 7, what homeowners should do. If you're in the affected area or zone, whatever you want to call it, do not panic. But get informed. Talk to a real estate lawyer. Talk to your lender before your renewal date. Don't wait until 1 week before maturity. Ask your insurance provider or title insurer what is covered. And if you're trying to buy in the affected area, make sure your subjects and due diligence are extremely tight. This is not the time to waive conditions blindly. This is not the time to assume everything is normal. And this is definitely not the time to rely on Facebook comments or ChatGPT for legal advice. It is important to understand that the Cowichan case is different from other claims around Canada, at least for now. For now, this case appears different from many historical land claims because of the interaction with the fee simple ownership. Section 8, the real issue. Here is the uncomfortable truth. There are two real issues here. First, Indigenous people have legitimate historical grievances over land. That part cannot be ignored. But second, ordinary homeowners did not create that history. They bought the home under the legal system Canada gave them. They paid market value. They paid property taxes for years. They borrowed from the banks and paid interest. They relied on lawyers. They relied on the land title system. So if governments fail to properly resolve land issues for generations, the solution cannot simply be to dump uncertainty onto homeowners. That's why this case matters so much. It's not just a legal case, it's a confidence case, a property rights case, a mortgage case, a reconciliation case, and a government accountability case. Am I personally upset with these groups or tribes trying to claim the land? No. It's a business move, and a smart one at that. I might do the same thing if I was told my entire life everyone was on my land. So here is my advice. Do not panic, but pay attention. If you own property in BC or Canada, especially in the areas with unresolved title issues, this is something that you need to follow. If you're renewing your mortgage, buying, selling, or investing, get proper advice early. And if you're unsure how this may affect your property, mortgage, or investment plans, reach out. I'm a realtor and a mortgage broker in British Columbia, and this is exactly the type of thing that I watch closely for my clients. Because real estate is not all about the price. It is about risk. It is about financing. It is about title. And it is about knowing what is coming before everyone else catches up. Like and share this video with someone who owns property in BC. And if you are serious about buying real estate, grab my best-selling book on Amazon, Rockstar Real Estate Investing. To wrap things up with one final comment, most of us, lawyers, politicians, people way smarter than me, have no idea what is really going to happen here. There's so much uncertainty and so much unknown, and the amount of money the province and the country is going to lose in taxpayer dollars, likely battling this in court, it's insane. It's very unfortunate that there's so much confusion, and I just wish things were easier. Until next time, I'm Jessi Johnson. Have a nice day.
Own your life.